Introduce yourself for the record.
Sure. My name is Giles Grover. I'm from the End Our Cladding Scandal campaign, which represents leaseholders and unsafe buildings across the country. If I tell you more about my background and bio, just a little bit more if you don't mind. Essentially, we formed in early 2019 a coalition of leaseholder resident groups across the country. I represent close to around 2,000 buildings now, leaseholders in 2,000 buildings. Personally, I've been a leaseholder since 2008. Became a director of the residential management company in my building in 2010. First told my home was unsafe in August 2017, and I've been heavily involved in the cladding building safety scandal since then, where it's particularly been clear that the nature of leasehold law has played an intrinsic part in the delays to our homes being made safe. Thank you.
Thank you very much. I start by calling Mike Amesbury, please.
Yes, good to see you, by the way. What are the main implications of this bill for remediating residential buildings? Are there some good things in it, Giles, and what's missing in it?
I think part of the issue, though, is that there are some good things in terms of for leaseholders in general. There seems to be some better things than there were. Part of the problem is, though, we still don't have that full clarity in terms of what the legislation will look like in final form. Supporting legislation is quite difficult to comment. On building safety amendments, I'm afraid to say I don't really know what's in there currently. I've seen, obviously, the opposition has tabled a couple of amendments, NC 27, NC 28, as a starting point. However, we've been lobbying the government, meeting the government, speaking constantly on almost daily basis to the government, having regular meetings, pushing for further protective measures to make the Building Safety Act operate as intended. However, I can't really see anything there. I've seen a press release saying we'll apportion leases, which is something we raised the Secretary of State a long time ago, talking about enfranchised buildings as well. But as it stands, I'm still waiting for the government to actually bring forward some building safety amendments that will actually mean that the homes that are unsafe, that have been unsafe, many of them 6.5 years, will be finally fixed at pace, at the pace we need and the pace we deserve.
Yes, there is provision to basically strengthen the accountability in terms of remediation for freeholders and ensure that those liabilities is held effectively more accountable. Are they strong enough at the moment?
Not yet. Again, I think that just had a look at the bill, and the 140-page bill didn't say anything about developers. Obviously, it talks a lot about the freeholders, but I can't see anything that will mean that those freeholders will now crack on with making our buildings safe at pace. I can't see anything that says what the mechanisms in place will be to oversee that. I fear that the reality on the ground is that the freeholders are still focused on mitigating their own liabilities. Historically, they've taken years, as one example, to sign grant funding agreements, delaying work starting on site. We've seen those same things happen with developers now. I think the wider point is that we've seen the Building Safety Act come into play in the 28th of June 2022. We're now looking at amendments that will make it operate as intended. So I think there needs to be a raft more amendments from the government. Some of the stuff we've been talking about in terms of the ongoing policy thinking. But ultimately, I think one of the simple things is that we've still got too many leaseholders ruled out of protection. We've still got too much uncertainty on the ground. So that King's speech, the paragraph that talks about making it operate as intended, it's got a heck of a lot of heavy lifting to do. And I need to see the detail before I can actually say whether it'll work or not. I fear, based upon my experience, it's unlikely to be the case. Really.
And a final one, do you think there should be amendment to extend the scope of the Building Safety Act because of the interplay with leaseholders? Because there are literally hundreds of thousands now excluded from the Building Safety Act in terms of those below 11 metres, those that might have more than 3 properties.
Yeah, I think, as I say, that the amendments that have been tabled, NC 27, NC 28, would go some way towards ensuring that those non-qualifying leaseholders of more than three properties are treated the same as qualifying leaseholders, and the buildings that the department, the government currently deems as irrelevant because they're under 11-metre buildings would be made irrelevant, would be made relevant. Sorry. So I think it's kind of worth kind of just setting the scene. When I gave evidence to the Public Bill Committee to the Building Safety Bill in September 2021, and there's a lot of talk about we'll do this, we'll do that, we'll definitely protect you. We then saw a raft of legislation come out from 10th of January up till or 14th of February. The problem is that it's all very high level, it's all very complicated. Some people might get some protection, some people might not. We're all the innocent victims of this scandal. So it still shocks me that despite the Secretary of State saying 10th of January 2022 that was showing a desperately unfair burden, industry will pay. 2 years later, I'm still talking to the government, public bill committees about what more needs to be done. It's all too slow.
Thank you.
Thank you, Mike. Andy Carter, please.
Very conscious you're a very different type of witness that we're hearing today, talking about the cladding scandal, and I think it's very helpful to get your insight into this. But I'd like to pick up on the questions that Mike has asked you, and I suppose it'd be very helpful if you could be as specific as you could. What's missing from this bill that you think is a real priority for people that are in a position where they are in a leasehold property where they can't sell because of issues in relation to cladding and remediation?
I think there's quite a few things missing. I think the first thing missing is the fact that what you should really do is say that there's no more non-qualifying leaseholders. There's no more people who are being arbitrarily ruled out of help, which you could do as an amendment to this bill. Some of the ongoing kind of campaigning, lobbying we've done, particularly with the Levelling Up and Regeneration Bill, we fully recognise that the government doesn't necessarily want to protect everyone. But the problem is it's spelt far too long apportioning liability, talking theoretical terms, and there's still too many ordinary people that aren't protected. So just going into kind of the specifics of some of this is where if it's not the willingness to say, okay, we'll protect all the victims of this scandal, which you really should be doing, then what we need to do is to say, okay, how can we better protect the ordinary people that still aren't protected, that the government says it wants to protect, that it should protect? That would then go back down to some of the conversations we've been having with the department, some of the amendments that have been tabled about extending property protection to first-three properties of all leaseholders, because that would mean that everyone would be treated fairly. Apportioning ownership that the government has said it will do in this bill to make sure that the marriage penalty, as it's known, will be done away with. And that there's one other point about the distinction of where non-qualifying leaseholders, it will be in perpetuity. So it's very worrying that particularly the non-qualifying leaseholders we speak to, that is literally hanging over their necks for the rest of their lives. Even if the building gets remediated, even if it's assessed as safe, they're still treated as non-qualifying leaseholders. So one of the elements, sorry, I forgot to mention, is that there's a potential portfolio size amendment that was tabled to the LERB that we think hopefully the department's looking at closely. Again, all leaseholders should be protected. If there's not the will to do that, which there really should be, then we need to do more to make sure that the protections, as they are, protect more people. Could go into a lot more detail, but I don't know how much you want.
No, that's very helpful. Thank you very much. Can I just one final question around the requirements for building managers to for regulation around that? Any views on that area?
Yeah, I've got a lot of views in that area. I think part of the issue was that so the Building Safety Act, there was building safety managers in place where there were certain duties. At the fairly last minute, that specific legislation was moved away from, but those duties still exist. So particularly for high-rise buildings that are now having to have registered with the building safety regulator, a lot of those buildings are now facing enormous costs of compliance, real fears around what exactly the work will need to be done, and we're just currently seeing bills land on our doorstep all over again I got one from my estimate, which I thanked Down Residential Management Company director. I could challenge it more, but it was going to be £500 per year extra per leaseholder to comply with the building safety regulator if we hadn't moved away from some of the strange costs that were in there. But I've seen it for other buildings where there's leaseholders who've just got a freeholder, they've suddenly got a demand saying you're also going to have to pay for compliance with building safety. So it's very worrying and strange that the innocent leaseholders that were meant to be protected are now going to have to pay just in a slightly different way to make sure the buildings that should have been made safe, that should be maintained, are going to have to be safe. Fire doors is another example that I could really get into if you want to. I've only got 20 minutes, so I'll hand back to you.
Thank you very much, Matthew Pennycook.
Thank you, Dame Caroline. Giles, thank you for giving up your time to come and speak to us. I wanted to follow up really on Mike and Andy's questions, and you may have said everything that you kind of can say in terms of what you'd like the legislation to do, but if you've got some more detail, I think it would be useful. I'm thinking specifically, we tabled, Mike and I, new clause 27 and 28 to kind of address some of the in-principle issues we've been pushing for a long time on non-qualifying, qualifying leaseholders and building height, but very specifically in terms of what feasibly the government might bring forward. What is your experience from cases across the country in terms of the operational elements of the Building Safety Act that aren't working effectively? I'm just trying to get from you what, in a more realistic sense, might you expect the government to bring forward in terms of extending this bill to ensure the Building Safety Act operates as intended? What are the tweaks to the Building Safety Act that are required, in as much detail as you can in the time you've got?
I think one of the major tweaks that we were first made aware of in November 22 due to a building in Greater Manchester, they were being forced to pay for interim measures. The council is now paying for those interim measures, but has been told that they can't recover those through the Building Safety Act because the legislation is not in place. So that could be a simple one that could help. You could ensure that resident management companies and right to management companies can raise the legal costs where they might be needed in respect of building safety and relevant defects. But there's also some of the wider elements already in the bill in terms of stopping freeholders recharging their legal fees. I think the concern we have is whether that will protect those non-qualifying leaseholders who are still being forced to pay fees. So I then get into, again, this is where I can get into the specifics. I'm no lawyer as such. You've had a lot of very intelligent people on before me, so I can sort of give you this from the campaigning background and aspect of it. But I do think that there's a fair bit more detail that we need to see in terms of exactly where a freeholder is avoiding its liabilities, where it's not given a landlord certificate within the stated time period. The government may tell us, oh, don't worry, that means they can't pass costs on. Well, I can't sell my flat, theoretically, without that certificate because the conveyancer is asking for it. So why not have an express duty for them to provide it? I'll be completely frank. The whole landlord certificate, leaseholder certificate process is an absolute quagmire and nightmare on the ground. So I'd personally prefer a way that they could do away with that. So there are lots of different ones like that. There's the points about court-appointed managers where they can't be the accountable person, which seems quite strange to me. We've been told that there's another route through the building safety regulator, but that would require special measures manager legislation to be enforced. There's issues with shared owners in complex tenures where you've got a housing association as the head leaseholder. Will they be protected from all costs? Will they have the same rights as all leaseholders? I think, again, sort of philosophically, it's a case of the simplistic approach should be that you have that full protection. Again, NC 27, NC 28 would help. That would be a massive relief. I think it's then a case of the stuff that is legislation needed, or is the current measures in place with the developer scheme where it's for over 11 metre buildings? Could that be extended to under 11 metre buildings? Cladding safety scheme that's now for mid-rise buildings, could that be extended for low-rise buildings? Could the cladding safety scheme be extended to be a building safety scheme? A lot of this, the pushback has always been there's not enough money, but there is money out there. There's money that can be got from industry. There's further parties such as construction product manufacturers and providers that the Secretary of State said they'll make them pay 2 years ago. They haven't paid yet. There's a lot more parties that could be brought into the pool. So operationally, there's more they can do in terms of actually just saying, we've got 7 different funding schemes, how many it is, where's the oversight of it, who's talking to each other, how are these regulators, how's the DLUHC talk, the Recovery Strategy Unit, are they talking to the Building Safety Regulator? Is Homes England involved? The local regulators that now have new money to take action, are they taking action? So a lot of it arguably is already in place, but it's that whole kind of oversight and the proper grip to say, right, all these buildings, 10,000, these are all going to get fixed. This is how, this is where the funding is coming from. Cladding costs are here, non-cladding costs will come from there. What you really need to do is put the money up front, recover it. The government says its leaseholder protections will mean that that leaseholders won't, the majority of leaseholders won't have to pay. If it's got the confidence in its legislation, then it can take over the burden from leaseholders.
Thanks, that's some useful detail there.
Thank you. Barry Gardner.
First of all, Dame Caroline, can I declare an interest? I'm not sure whether it's necessary, but our witness, Mr. Grover, participated in a documentary that I'm making about leasehold, so we have a knowledge of each other. Mr. Grover, first of all, thank you for all the campaigning that you and your colleagues in our cladding scandal have done. It's been quite magnificent over the past few years. I wanted to ask you specifically about, you raised the issue in response to Matthew Pennycook's questions to you about Section 24 and applying for an officer of the court to be installed to do the works and turn around a building. And clearly it would be something much to be wished for many people who found themselves in a building safety issue if they were able to do that. And related to that, I know you are aware of the Building Safety Act 22 ban on Section 24 managers being the accountable person. Now this is a matter we've discussed with a number of witnesses such as yourself. Are you aware that at one development the management control was given back regarding safety and remediation to a freeholder who was the one who took, the tribunal found, £1.6 million in insurance commissions unreasonably, and they will now be handed £20 million because of that BSA anomaly by the government. So the very people who could not be trusted with money are now being given £20 million to remedy the defects that they were responsible for in that building.
I'm very aware of it. I've obviously watched some of the sessions, and I was made aware of it last year as well by one of the leaseholders at that building. And to be honest, I mean, I've looked into this. I've had various conversations with various lawyers. It still just seems bizarre that a manager that's been appointed by the court can't be the accountable person. I'm just a simple man. I don't really understand why that can't happen and why the government or the judge, based upon the legislation that's out there, thinks it's a reasonable or positive outcome for that money to go back to that rogue landlord, shall we say. I don't get it, to be honest.
And have you come across cases, I have one in my own constituency, where the developers, it was a co-development between St Modwen and Southcrest, but when the provisions that the government put in place came into force, they changed to Wembley Central Apartments Limited. That was then changed to Wembley Residential Limited, and they now have their offices at what is, I think it's Cricket Square, Grand Cayman in the Cayman Islands. Have you got other examples of the ways in which freeholders are using company law to avoid their obligations under this Act and in fact relocating to jurisdictions out with the UK?
Yeah, I think I've only got 20 minutes, so I'll try to be brief on that. I don't have much longer left because I could literally spend all day talking about that. I've had personal experience of that in my building where our developer sold the freehold out from under us to an offshore freeholder who 1 year before the building safety crisis took effect said they don't want to sell the freehold because they're long-term investors. A year or so later, they said, okay, we're transferring it to another company. Do you want to buy the freehold off us?
Order.
Because they saw...
I'm so sorry. I'm afraid that brings us to the end of the allotted time for the committee to ask questions, and indeed for this afternoon's sitting. I do apologise to the witness, but I do thank him very much on behalf of the committee. The committee will meet again on Tuesday to begin line-by-line scrutiny of this